Hi friends, I am Isha Sharma, founder of Trayambak, and today I'm here to basically talk about copyright laws. So let's start with the definition itself. Copyright application is a form of IPR which gives you exclusive rights over your creation and to exclude others from using the same without any getting your prior permission to it. Now we'll be discussing different categories under which you can file for a copyright application. First is a literary work. So anything which is related to, say, probably a novel content or a new software or a training module can be filed under literary content. Second thing is your artistic work. So if you're a photographer or if you're a painter, you can consider filing your copyright applications as well. Third category is your musical category, under which if in case you're creating any kind of a music, then you can file for a copyright application. Now in the music category, it needs to be understood that there will be like multiple people involved in creating music. So if you're a composer and if somebody else is writing the lyrics and somebody else is singing it, so there will be different multiple rights given to those individuals. Apart from that, we also have a category which is your dramatic work. So your TV plays, your shows, your movies, all these things fall under dramatic work. In addition to it, you can also file for cinematographic as well as sound recording works. Now, in this video, I'll be more focused towards answering few questions that I hear pretty often from people and they're confused about the answers. So first question is that whether it is mandatory to actually file for a copyright application or not. So ideally speaking, according to Act, it is not mandatory to do it, which means that the moment you create, it is given that it is your creation, provided that you can prove that. So basically, whenever you're working on something, it is ideal scenario to write down your date and your day and somebody to verify that you created it. Now in this scenario itself, it will be an ideal situation if you file for an application and the government itself grants you a certificate which says that you are the owner of that creation. Now let's move to the second question. So people usually ask me whether we should file for an application once it is published or before publication. How does it go? So unlike your patent applications, copyrights can be filed for both your published as well as non-published work. Third question comes from tech industry. So as we see that most of the innovation is happening in your technical world, so be it AI related inventions or robotics or softwares or apps are being created for multiple purposes. So for these kind of businesses, you can consider for filing a copyright application, provided you submit it as a source code and an object code. Taking an example of a website, say website basically will fall under literary work if you're filing the code aspect of it. In addition to the code that you create for your website, you can also file for different categories which are covered into a website, which can be the content or which can be the photographs and the videos that you use. So ideally speaking, there will be like multiple IPs which needs to be filed to protect a website. In addition to that, I will also like to highlight the point that copyright application doesn't cover the functionality part of it. So if you're concerned about the functionality of a website, copyright applications are not the ideal scenario for you. Apart from that, it doesn't cover the layouts and the look and feel of a website as well, and same goes for your apps. So that should not be considered for filing a copyright application. Apart from that, the fourth question which comes pretty often is that how to identify that this is a copyright subject matter. So most of the times, if you pay some attention, you will see that there are watermarks present or there is a symbol like C within the circle. So that automatically means that it is a copyright subject matter, and there will be a date associated with it as well. Apart from that, there are different societies which are formed to give certain licenses to different people to use the copyright protected subject matters. So just to name few, say there is an IPRS society, which is Indian Performing Rights Society, which basically gives you a right over a literary content associated with music. Then we have IRRO society, which is for any kind of a photocopying work or reprographic work. Then we also have Singers Society, which is ISRA Society, which gives you the rights for performing certain kind of a music in any kind of a setting or an event for that matter. Apart from that, I will also like to highlight one point, that when you're making any kind of business arrangement with your copyright subject matter, the agreements that you're going to write should always include those IPR clauses and confidentiality clauses, even if you consider for filing a copyright application or not. That should be written exhaustively so that you are on a safer side. I hope it was useful for you, and please stay safe and stay home. Take care.